YNW Melly's defense team filed a motion to dismiss the entire case for misconduct and violation of Melly's due process rights. This involves the incident with Melly's mom and the lead detective Moretti, where the detective forcibly took her phone and injured her wrist. Yeah, Melly's team is trying to throw out this entire case, and it's actually kind of crazy. The last half of this video, I read what happened, and it's pretty wild. So yeah, stick around for that. If you're new to my channel, subscribe. Let's go right into this video.
I know you filed 13 motions to suppress. I know you filed several other motions, a motion to dismiss, and we'll figure it out.
So the stream is chalked. It's only 10 minutes long, and the audio is terrible, but he just said, I know you filed 13 motions to suppress. He said, we'll figure it out at a later date, I believe. Look how wild of a picture it is. Judge, prosecutor, 4 fucking lawyers right here for Melly. He just said, I'm not stopping the trial. So the trial's staying on schedule, basically, is what he's saying.
And there's approximately 200 other lawyers in that office that can cover the demo.
They want to do a deposition, but they have to have the prosecutor present there, and she's delaying it because she has scheduling issues, like other things going on. But Melly seems like, what the fuck? They have 200 different lawyers in their office that could cover that deposition and be there. And the judge even said, I understand that.
You're saying you're ready to try the case. The state is ready to try the case. So we're just going to move on with it on the, what date is it? 19th. So
This audio is terrible today. Wow. I don't think they have the microphone plugged in it. They're discussing now which courtroom they're going to use. I believe someone wanted a bigger courtroom, and the judge said it's not up to him, but he's going to try to get a bigger courtroom.
Quite candidly, we'll be lucky if we pick a jury before Thanksgiving because of the holidays scheduling. So
Did he just say we'll be lucky if we pick a jury before Thanksgiving? Don't tell me this trial is starting in December, and then we're going to have to take 2 weeks off right when it starts for fucking Christmas. They might as well delay until January 5th or whatever they decided to come back last video. Like, why even start it in December and then take 12 days off for Christmas? Melly must like Stuart Aldestein a lot for making him his lead attorney now. I'm surprised with that decision. I feel like this decision was a little rushed, because I wouldn't have made Stuart my lead counsel, my opinion. You know what I mean? I would have definitely kept David Howard. Alright boys, if you want to see Uzi, Yachty, Trippie Redd, or Skies live on tour this fall, click the link in the description and buy some tickets down below, alright? Some sick fall tours for those 4 artists right there, so go cop some tickets right now. Back to the video.
we have good
That man stays smiling walking in and out of court, dude. Happy as hell. So we got another motion in limine right here for a promotional video. It says the promotional video done by the defendant, which concludes with 4 days after the completion of this film, Melly and his friends were the targets of a drive-by shooting in Miami, Florida. Juvie and Sack Chaser were killed. The frames of said video on which of the screen is written 4 days after the completion of this film. As grounds for said motion, the defendant states the following. The state seeks to introduce this video along with the frames with the above listed paragraph. The state contends, which is reflected in police reports and other statements made, that this frame is tantamount to a confession that the defendant was present at the time of the shooting of both Anthony and Christopher. However, regardless of the state's desire to connect this statement with the defendant, evidentiary-wise, they cannot. So yeah, I remember the state saying that was a confession, and they showed that to the jury, that, you know, he even admitted in his own fucking documentary that he was present and they got in a drive-by shooting. Now Melly's team is saying that that's not a confession. This video is emanated from the promotional site, not from a personal social media account of the defendant. First of all, the statement is in third person. It uses the name Melly in the third person. Obviously, this is not a statement made by Melly, therefore this is not an admission at all. There's no evidence that Mr. Demons had any control over the video as to the things in the message noted above. In fact, the frame itself speaks to the point that it came well after the video had been completed by the defendant. It says that 4 days after the video was completed, the shooting took place. Therefore, there's nothing on the video that indicates the defendant knew about the statement, adopted, or had any control of the statement being put in as a tagline to the video. Obviously, an editor put that in there, whoever, you know, produced the documentary and edited it. But in my opinion, it's his team admitting that he was there and they didn't realize it would bite them in the ass. You know what I mean? That's what this is. But in court, they can't argue it. It could be hearsay in court. The contents of that statement are classic hearsay, yeah. It is being offered to the truth of the matter asserted, not that the defendant was a victim, but rather that he was present, is being offered for that truth. The contents of that statement will be based upon hearsay. Where did this person that wrote this last screenshot get this information from? Newspapers, blogs, social media? Unless the person was there at the time of the shooting, it would be based on hearsay. Further, the statement says that the event took place in Miami, not Miramar. Ooh. He's being brought in for the truth that the defendant was at the scene of the shooting and is only relevant to the shooting that occurred in Miami. Damn, look at this lawyer find little loopholes in the... Since the statement cannot be authenticated to have been made by the defendant, or with his knowledge and consent, or with his ability to stop its publication, the statement has no relevance in this case. Fuck, dude. They might be right, man. They're convincing me. Even though it's like common sense, clearly someone who edited it knew that Melly was there and like talked to him, but you know, the statement is actually double hearsay. As the statement itself is not only an out-of-court statement made for the truth of the matter asserted, but the information in the statement is gleaned from another source which would also be hearsay. The only material fact that the state would be offering the statement for is to prove that the defendant was at the scene of the shooting. As noted above, if the defendant did not make or adopt this statement, then it is not an admission and it is hearsay. If the state is contending that it is an admission statement by the defendant, they must show that there's evidence sufficient to support a finding that the matter in question is what the state claims. Since the statement is hearsay, double hearsay, and it cannot be authenticated, its prejudicial effect far outweighs any probative value. Allowing this evidence to be introduced would violate the defendant's due process rights as guaranteed by the 14th Amendment of the United States Constitution. His team's kind of convincing me, boys. I'm gonna be honest. They're like shitting on that. The fact that it said Miami when it was actually Miramar, technically, that could be, you know, a little hole. The fact that it's clearly like typed by someone who wasn't Melly because it was in third person. It was like an editor that typed it. Common sense would say, no, that's your fucking editor saying the truth because he knows you were there. In court, that won't hold up because it could be deemed hearsay. So a little bit of a W for Melly's lawyer right there. So here's the bombshell amended notice right here, which means they're changing something that they already put in the court system, pretty much, that they already put in. On October 12th, 2022, on the 7th floor of the west wing of the Broward County Courthouse, Miss Jamie King's statement was taken by Miramar Detective Mark Moretti and ASA Michelle Boutros. Also present was Mr. Robert Trackman in his capacity as Miss King's counsel. The Robert Trackman is Melly's mom's lawyer. So this is about the incident where the detective fucked up Melly's mom's wrist, right? This is big here. Listen up. During the statement, Sergeant Hendrick left the conference room. Shortly thereafter, during the statement, while no BSO deputy was present, Detective Moretti seized Miss King's phone pursuant to a search warrant. So no one was present in this room besides her lawyer and her. Miss King and Mr. Trackman then left the room. Shortly thereafter, BSO deputy Adam Gorel arrived at the conference room. According to ASA Boutros, it was at this time that Detective Mark Moretti stated to BSO deputy Gorel in front of the ASA Boutros that Deputy Gorel should say that Deputy Gorel was present when Detective Moretti seized Miss King's phone. So he's telling another deputy to basically lie on the record and say he was inside the room. That's a huge red flag for a detective to lie and try to get someone to say that they were already in the room. That's showing that you are guilty of doing something you probably shouldn't have been doing, clearly. According to the information from Boutros, Deputy Gorel nor any other BSO deputy was present in the conference room when Miss King's phone was seized by Detective Moretti. So Boutros and Gorel snitched on Detective Moretti and said, we weren't in there, but he told us to lie and say we were in the room. What the fuck? Dude, this is a little shady ass detective, I want to be honest. The lead ASA assigned to this matter relayed to SAO administrators that she spoke with Moretti in regards to this incident and that Moretti explained that his statement to Deputy Gorel was a joke. This detective is saying it was a joke. Why is that a joke for you to say, hey, by the way, say that you were in the room with me? Is that not the biggest of red flags you've ever heard for a detective? To try to get someone to lie on record that they were present in a room where they just seized someone's phone in a search warrant? The lead ASA subsequently filed a Brady notice with the court on September 23rd, 2023, which stated that Detective Moretti told her that Detective Moretti asked Gorel if Gorel was there when the phone was seized, and Gorel responded something to the effect that, I can be if you needed me to be. The bro's like, yeah, if you want me to go on record, I'll do it, I'll lie, but then he ended up not doing it. That detective is a little shady fucker. That was not a joke. That was him trying to cover his ass and have witnesses in the room for something that clearly just occurred minutes beforehand before everyone left the fucking room. That's how this works. That's common sense. A lot of you are probably asking, what does this even mean? This is the lead detective in the case. The lead detective in the case. This could be big implications for the trial if this gets brought up in front of the jury. I don't know if it's going to be allowed in court, but it might be in cross-examination and everything. So that's why this is serious, because the jury could be like, wait, the lead detective did what? And he lied about that? What else has he lied about? That's what they're going to start thinking about. We got a motion to dismiss for government and prosecutorial misconduct and violation of the defendant's due process rights. The defendant was tried in the above-styled cause from April 10th to July 22nd. The results of the trial was a hung jury. His credibility reliability is not only germane to this case, but has direct bearing on the outcome of this case. The jury's estimate of the truthfulness and reliability of a given witness may well be determinative of guilt or innocence, and that it is upon such subtle factors. So here's the Brady violation stuff. For the defendant to establish a Brady violation, the defendant must show the evidence was favorable to the defendant either because it was exculpatory or because it was impeaching. It was suppressed by the state either willfully or inadvertently. It was material, therefore causing prejudice to the defendant. Although the state has no obligation to provide Brady material, nonetheless, on July 25th, 2022, the defense filed a Brady request. The defense has been requesting of Assistant State Attorney Christine Bradley information in regards to the investigation as to what occurred when the phone of Jamie King was seized. The response has been simply that there are certain named witnesses under investigation. So a month ago, on August 23rd, 2023, the defense served another Brady request. This was for information in regards to the investigation of Moretti for excessive force used against Jamie King. On August 30th, Ms. Bradley responded to Internal Affairs. In essence, Ms. Bradley stated that the investigation was closed and no wrongdoing was determined. Ms. Bradley also asked what the best procedure would be in order to take the deposition of Assistant State Attorney Michelle Boutros, who was present when the phone was seized. So they want to take a deposition of one of the Boutros that overheard Moretti telling them to lie, basically. Ms. Bradley responded that the office required a subpoena and then interjected that, however, Michelle Boutros was very ill and at home, certainly giving the impression that she was too ill and infirm to be a part of this matter. Oh yeah. So the lady who overheard all this, who was present, just so happens to be so sick she can't get on a little Zoom call or something, huh? This is fishy as dude. Ms. Bradley was also asked if we can get Ms. Boutros' sworn statement. Bradley responds she does not have the file. Subsequent to that conversation, counsel for the defense learned that, in fact, Ms. Boutros has been working and is available to go in the state attorney's office. Wow. I told you they were lying about her being sick, dude. This is crazy. So they're trying to get the details of this event that occurred, and people are lying about being sick in the state attorney's office. How corrupt and bullshit is that? The defense has sent Ms. Boutros for deposition on Friday, September 29. Counsel for the defense has also learned that day, again after the conversation outside of the courtroom with Ms. Bradley, that Ms. Bradley, in contravention to statements made to the defense, was actually quite involved in the matter, including having conversations with the head state attorney and the assistant to the chief in regards to Detective Moretti. So Ms. Bradley lied about even being involved a lot. State attorney's offices can be so goddamn corrupt sometimes. Later that day, Mr. Aldecine, by letter, confronted Miss Bradley. Detective Moretti executed a search warrant outside of his jurisdiction, and therefore illegally. It would have allowed the defense to question him as whether he committed a robbery or battery on Jamie King when he unlawfully took her phone. It would have shown that Detective Moretti was willing to lie as to who served the search warrant, an official court order, and it would have shown that Detective Moretti was willing to conspire with Deputy Gorel to obstruct the justice and create false filings. I was always confused about how when Melly's mom went on No Jumper and said that this search warrant wasn't supposed to happen and it was like wrong. Now I understand. Apparently it was outside of the detective's jurisdiction and he still forcefully took the phone. That's a red flag. This is not a good look for this detective. This was impeachment evidence favorable to the defendant. The first prong of Brady is met. Rather than presenting this to the defense so that the defense could have used it during the first trial, the state withheld this information. In fact, it is believed the highest levels of the state attorney's office made determinations to not provide it to the defense, and secondly, not to pursue the internal affairs investigation. This was institutional policy of state attorney's office, not just one prosecutor. Affirming the denial of the defendant's motion to dismiss as there was no showing of institutional policies of state attorney's office. This evidence was suppressed by the state. The second prong of Brady is met. This lawyer's snapping, dude. If this state attorney's office really hid all this information, this is kind of fucked up. Like, this is not fair. I'm the first guy to say that all the evidence points to that back seat that Melly was in, and that it is, you know, a bad look for Melly because it looks like he kind of did it. This should be addressed for sure. The unfortunate stark reality is that the state intentionally withheld this information that would impeach Detective Moretti in order to gain a tactical advantage and to violate Mr. Demon's due process rights as guaranteed by both the 14th Amendment and the parallel provisions of the Florida Constitution. Because withholding of this evidence was not only institutional, but deliberate prosecutorial misconduct, double jeopardy principles apply, and the case must be dismissed. And then they cite another case that's happening. They're asking for a dismissal of the entire case, bro. Can you imagine if this actually goes through? I feel like it might be too good to be true, but knowingly used by the state authorities to obtain his conviction, and from the deliberate suppression by those same authorities of evidence favorable to him. These allegations sufficiently charge a deprivation of rights guaranteed by the federal constitution. Proven would entitle petitioner to release from his present custody. Dude, this is crazy. This lawyer's kind of snapping, boys. No one knows the proverbial what if. However, given the hung jury and the inability to cross-examine the lead detective in this case as to his role and desire to skirt or break the law in furtherance of this investigation, it would have changed the outcome. And they just keep citing like 3 cases right here. Obviously, Obviously, they were planning on allowing another trial to go by without revealing this information. Only after the defense started to uncover what happened on the date between Moretti, DSO deputies, and Jamie King in the presence of an assistant state attorney was the state forced to reveal what has been hiding. That's kind of true. They got caught with their pants down and they were like, oh shit, how'd they find that out? Like literally caught jerking off. Although the defense has only uncovered the tip of the iceberg in this matter, this tip is sufficient for this court to determine the defendant's due process rights, as guaranteed by the United States Constitution through the 14th Amendment and the provisions of the Florida Constitution, that his fundamental rights have been violated and that the only remedy is dismissal to let him free. Dude, holy shit, did this detective up. Can you imagine if this happens? This was just filed yesterday too. Jamie Benjamin, Melly's new lawyer, is snapping. How'd they find out that that lady lied about being sick? Oh my god, what a disaster for the state attorney's office. We have another motion in limine, agreement between Demons and Williams as to sharing of any money. So remember how there's arguments about money between Melly, Sack Chaser, I believe. Basically, Sack Chaser thought he was like owed money for being the CEO, which is kind of delusional. I know he's, you know, passed away now, but let's be honest here, that's a little delusional. Procedure to issue order preventing and precluding the state from mentioning or eliciting testimony that the defendant Jamel Demons owed Anthony Williams any money. That there was an agreement between Jamel Demons and Anthony Williams to share or split all of the money Mr. Demons made through his musical pursuits. Unless the state can present a signed contract or agreement, a verbal acknowledgement by Mr. Demons that he owed the money to Mr. Williams, or correspondence by Mr. Demons that he owed Mr. Williams money, any reference to it would be pure hearsay and conjecture. The state has no motive as to why Demons would kill two of his best friends. Yeah, this was a big motive about the money situation. They're trying to get that out. They're trying to throw that in the fucking trash can, saying that that is all, you know, conjecture and that it's not really proven. There's no contracts. But I mean, if there's text messages of them arguing, there's text messages of it. It could be, I don't know how I feel about that. The nature of this testimony referenced above would be brought in so that the state could argue there was a motive for Demons to not want to pay Mr. Williams the money. Before the state contends during an opening statement that it will show this evidence, the court needs to rule on the admissibility of this argument. So yeah, they're trying to throw that out because that's probably a big selling point for a lot of the jury. He owed them money and he just wanted to kill him to get rid of him. So I can see why Melly's team is trying to put that out there, but will it happen? I don't know. Will any of this go through? I doubt it. To backstep and say it was a joke too is such a L, just showing that you got caught. If you're on my channel, subscribe. I'll keep covering this. I'm on Twitter and Instagram. Patreon for body cam reactions on the screen right here. Love you boys. Peace out.